morning.
Good morning.
How's everybody doing today?
Fine.
You?
I assume the green seat is the hot seat.
Yes, you get the bright green tablecloth so we can see you, that way we don't miss you.
At least I don't contrast too badly.
You actually blend perfectly, you match. Well, good morning, Judge. Thank you for being here with us this morning. We are going to go ahead and get started since you were here early, and if that's fine with you, we will get you out of here so you can get back to Brevard County.
Thank you very much.
My name is Amanda Carl. I'm the Vice Chair of the 50 JNC. We welcome you this morning. You haven't been with us before, so I'll explain kind of how we work and how our format will work. All of the commissioners will go around, introduce themselves, and tell you where they're from. We will then give you 2 minutes if you would like to make any opening remarks. We'll follow that with questions, and then we'll reserve some time at the end if you'd like to make any closing remarks to us. As you've probably seen, we have Lucia exposed here today that will be videotaping. So sit up straight, give them your best side, and we will go ahead and go. David, if you'd like to get started.
I'm David DeArmas from Kramer Price and DeArmas in Orlando.
Good morning, Your Honor. Vince Citro from the law offices of Horowitz and Citro in Orlando and Tampa.
Good morning, Andy Bardos with the Gray Robinson Law Firm.
Good morning, Brett with Johnson Law in Orlando.
Good morning, Your Honor. Pedro Brownlee with the Brownlee Law Firm.
Craig Dyer, Public Defender's Office, Daytona Beach.
Thank you. It's very good to meet all of you. As you know, I'm Tony Rainwater. I'll start out from the beginning. I was born out of the state of Florida, but we moved here when I was not walking yet. So although I'm not a Florida native, I learned how to walk in the state of Florida. I grew up in Brevard County, spent my whole life there as a child. Then went off to college at the Florida State University. I went off a year early. I was tired of high school and was able to get accepted a year early and started a year early. Finished college in 3 years, went to law school directly at the University of Florida. Go Gators. And finished there after 2.5 years. I just went straight through. So at the age of 22, I had my law degree. I then took the bar and passed and started my career as an assistant state attorney in Brevard County, prosecuting misdemeanors. I left that office after a year and a half because of various reasons, but I wanted to start my own practice. So I was in private practice for several years, and an opportunity arose. I decided to run for county judge and was elected in 1986 and began my career as a county judge. 4 years later, when an opening occurred in the circuit court, I ran unopposed for the circuit court, which is unusual to have an unopposed election for your very first election, so I was very fortunate in that regard. I like to tell people that I graduated in 1974 and 1976 and 1978 because after going to college for a year, I was able to come back and graduate with my graduating class at Melbourne High School. 10 years later, I earned an MBA, a Master's of Business Administration from Florida Tech, and that was something that I had started before I became a judge, and I only had 3 or 4 classes to finish, and I decided that's something that I really wanted to finish up and not leave hanging. And so I went to school at night, 1 class a night while I was working full-time as a judge, raising one child at the time. I was pregnant with a second, and finished up before the second child was born. I've served as a circuit judge in the 18th Circuit for 28 years. I've served in every division of the circuit court. I've handled criminal cases from possession to capital murder cases, including several death penalty trials. On the civil side, I've handled every type of case from your small claims or small credit card cases up to medical malpractice and condemnation cases. I even recently tried a tobacco case to a verdict with a $36 million verdict about a year ago. I recently handled a complicated construction litigation case in which we started out with several defendants, maybe 20 or more, defendants and third-party defendants. They brought in all the subs. The very first hearing I had with that, somebody brought me one of those charts that had like a family chart, you know, who is suing whom and where they go, and with all the signs going back and forth. I recently tried a very interesting deed or contract reformation case. It involved a complicated mutual parking easement contract between a small restaurant and the shopping center. And I was pleased that this was recently affirmed by the 5th BCA. In family court, which was my passion for many years, I handled several cases. In fact, I rarely recuse from cases, even if it involved lawyers that practice in front of me. They didn't ask me to recuse. In fact, they preferred that I would handle it because they knew that I would try to be very fair and to both sides. I also served in juvenile delinquency and dependency, and I'm currently in the probate division as the chief judge of the 18th Circuit, and I'm getting ready to go into guardianship and handle those, which I've handled in the past as well. I've served as the chief judge of the 18th Circuit twice. I've served as the administrative judge for Brevard County, the administrative judge in the felony division, the administrative judge in the family division, which was over the entire circuit, the administrative judge in probate, the administrative judge in guardianship, the administrative judge in juvenile. I was the appellate administrative judge in Brevard County for many years, which entailed reviewing all the motions that would come in on the appeals, assigning them to a 3-judge panel. Sometimes I had to rule on motions, and I think one of my writing examples was from one of those motions. I've served several times on the education committee before the circuit, and I've taught many courses at the conference and at the judicial college. And I'm certified as a mentor judge as well. I can go on.
I think we'll go ahead and start questioning.
Okay.
Good morning, Your
Good
Honor.
morning.
I had the privilege of vetting and talking to all of your references, and they just glowed about you. Your years on the bench are impressive, and the cases that you've been involved with, and the experience is undeniably impressive.
Thank you.
So thank you very much for everything you've done for the county and the judiciary as a whole. I've just got a couple of questions in your application that we've talked about. And you know, I noticed there's several times you've applied to FIT, the last being in 2008, and then we've had a number of openings since then, but I haven't seen you before. I was curious why.
Well, my husband and I have had a long time goal of retiring in our 60s, early 60s, and as I've gotten closer to this milestone in my life, I'm thinking, I really enjoy being in the law. I really enjoy what I do. The legislature recently increased the retirement age to 75. So I thought, this is a good time to do what I want to do. I'm ready to change from trial court. I've done everything I can do in trial court. Just continue doing what I'm doing, but I'm ready for something different. I've sat as an associate judge at the 5th. I've sat on local appellate panels. I really enjoy the discourse among colleagues about the areas of the law and to fine-tune what the issues really are. And that's what I think I bring to the table here. And that's partly why I haven't applied before. I've talked to my colleague, Judge Harris, who recently was appointed, and he's been glowing about how nice it is and how much he's really enjoying his experience. And I've received encouragement from a lot of people, why haven't you applied? So I said, this is a good time to try again.
And I see that there were 5 applications you've done in the past. Had you been put up on the short list in any of those 5?
I had never been privileged to make the short list before.
And then one other, in your application, talking about the contribution you believe your selection would bring to the position, you talk about that you've successfully advocated your position on controversial issues while maintaining a good working relationship with the judges and other staff members involved. I was curious, what controversial issues are you referring to there? Because you've covered a lot in your career.
I have. Mostly about interjudicial relationships. One of the things that I was passionate about was family law and the importance of having a separate family division within the court system in our county. We had the number of judges that would support having a separate family division, and I thought that the people are better served if a judge is concentrating on one type of case rather than having to roll jury trials as part of the civil cases into the family realm where you're dealing with injunctions and emergencies, you know, children that are being spiked by the parents, those kinds of things. And on the other hand, when you're doing civil, having to be interrupted with these emergencies that are a problem is also an issue. So I was successful in advocating, after several failed attempts, for a separate family division, which we've had for the last 6 or 7 years. I'm currently the chief judge, and we have recently had some strong request from the Public Safety Commission to resume having 6 felony circuit judges. And in order to do that, you have to pull somebody from some other area. And so I've successfully worked with the county judges to take on some of the load for the circuit court. In fact, it's starting next week, January 1st, we're gonna have 6 felony judges. And that's one of the reasons I'm switching from probate to guardianship, because the probate can be divided up a little easier than guardianship can, so. Those are some of the examples I'm talking about.
What is the longest that you've taken as a judge to issue your ruling on
On motion.
a motion or a trial?
Trial, I can tell you, sometimes it's been a while.
Okay. What's a while?
3 or 4 months.
Okay.
Generally, I take to heart when we have those little emails that go out every month that say you have to report how many cases are over 60 days. I don't like to report those, so I've really struggled to make sure that that gets taken care of on a regular basis. It's very rare that I have them over 60 days, but on, maybe 3 or 4 occasions over the last couple of years, I've had 1 or 2 that have showed up there.
And what do you think is the biggest current challenge to courts being able to maintain their integrity or independence right now?
Well, one of my personal challenges that I note, especially in the family division, is the requirement to very strictly set forth all of your findings. We don't have individual staff attorneys assigned to each judge. We share staff attorneys among the circuit judges. And so we don't have somebody who can really help with formulating those findings. So that's one of the reasons the family court is a difficult one to go into, and it's difficult to get judges to stay in those positions. I think the public sometimes perceives us as politicians, and that's a problem for the judiciary, because we are supposed to be fair and impartial. We're not supposed to be politically active or advocating for one party versus another, and that's just a challenge we have, a continuing challenge, because some states still do things that are partisan. Judges are elected on partisan politics.
Well, thank you very much. I'll let some of my colleagues ask some questions.
Question, you mentioned the tobacco case you had recently. What were a couple of the real more difficult issues for you that were presented that you thought you had to rule on based on the information provided to you? I kind of know that a case like that would have had some pretty challenging issues.
Very much. In fact, what happened with that...
post-trial motions. So.
Yes. What happened with that case, it had been started the year prior with my predecessor judge in that division, and he retired in that January. And so it had gotten mistried because of one of the hurricanes. It was like, I don't remember if it was Charlie or one of those hurricanes. The courthouse closed down and they weren't going to be able to finish, and so they just mistried it and said, we'll come back. So I took over. All the pretrial motions had been ruled on by the prior judge. Well, I come in at the pretrial conference and they said, Judge, here's an order that verifies what Judge Maxwell had done on his rulings. I said, well, I wasn't the one that made these rulings. Are you agreeing that I can enter this order? Because I haven't heard these motions. Yes, Judge, we're agreeing to that. And so, based on their agreement on the record, I did this. But then during the trial, those issues came up, and I would take pause, and I would go through it and say, well, I agree with his ruling. If I'd been making the ruling, I would have ruled the same way. So that was a little challenging to take over some other judges' rulings. During the trial, issues came up about comparative negligence. Shoke had not been decided yet. And so I allowed comparative negligence to go to the jury. And the jury came back with a very small percentage of comparative negligence on the part of the spoker. Well, between the trial and the time that I signed the final judgment, the Supreme Court ruled on Shoke, which said that comparative negligence doesn't apply in these types of cases. So essentially, I just ruled that they get the whole verdict, not the smaller verdict. That case is on, I'm sure it's on appeal now. I don't know where it is in the appellate process. The trial concluded last fall, and I think I did all the post-trial motions in early spring this year.
Were you asked if the verdict shocked the conscience of the court, anything like that raised?
On the final, the post judgment, yes, to some extent, but the compensatory damages was 12 million, and the punitive was 24. And it was divided between the two defendants, and it certainly didn't shock the conscience. It was certainly more than they had agreed to settle for, than they'd asked for. So, but it was an interesting case.
Ron, is there a case that you have read recently that you found to be particularly well-reasoned, and why?
I read the advance sheets every week. I try to stay up on them. I pull out the ones that affect my personal cases. I can't pick out any in particular on that issue. I'm sorry. Can't answer that question for you.
Judge, how would you describe your judicial philosophy?
My whole philosophy is to listen to the people, it's their case, and to rule on the facts if I'm the fact finder, to rule on the law as applies to those facts, that's my role, and to try to be fair both sides. It's kind of, I think the whole idea of judiciary is you want a fair judge. And one of the things I've experienced as a lawyer on occasion was having judges that prejudged the case because I was the young lawyer, prejudged the case because it was 2 o'clock on Friday afternoon, and I was a prosecutor, and okay, well, I'm just going to JOA this because we're done, and I felt strongly and passionately that I had a case and it should have survived a judicial judgment of acquittal. I experienced a time with one of our judges when I was a lawyer who threatened to hold me in contempt of court, and the comment was a Friday afternoon, I will tell you, and the comment was made to me that if you were a man, I would hold you in contempt and put you in jail. And I did not say I should be treated the same as a man. But I'm thinking that, and there have been other incidents with this particular judge, and he was up for election a year or two later, and even though I was very, very young, I really thought somebody should run against him, and I was not hearing about anybody who was going to run against him. I considered doing it myself when I heard that John Antone was going to run against him, and so I jumped right in on his bandwagon, and I actually was his campaign treasurer, and worked really hard on electing John Antone, who's become just a wonderful judge and a colleague for several years until he went to the Fifth, and then he went to the federal court now, senior judge of the federal court. So he's a personal friend, and I'm so happy that he took over because he was much, much better as a judge. Well deserved for him. You're welcome.
Judge Rainwater, my question is about constitutional interpretation. How do you go about interpreting a provision of the Constitution? So, take for example a recent amendment to the Constitution. What sources do you look to? What facts do you look to? What is your method or process for determining what that constitutional provision means?
First of all, I read it very closely. If there's some questions about the reasoning behind it, I will sometimes have a staff attorney look into some of the legislative history or the history of why it was brought in. If it's been in place for a long time, obviously I would look at what other courts have, how they have interpreted it. So just as I would interpret statutes the same way, you look at what the statute says, you read it closely, and sometimes I'll disagree with what an attorney's interpretation is, and I'll explain that. And a lot of it has to do with just nomenclature. You know, the statute says this is going to happen or this. So does the or modify the whole thing, or does it modify just the last part of what the or was? And it's really hard to determine that sometimes until you get out of the context and you look at things that have, other cases that have interpreted that. I try to look at the plain language first and the intent of the people if it was an amendment, or the legislature if it was a legislative statute.
And in the case of a constitutional amendment, do you read the text of the Constitution as reflecting the intent of the people, or is the intent derived from other sources outside of the text?
I'm not sure it's the judge's role to go outside of the text, unless it's part of, like, legislative history to come up with this, but that's the problem with the constitutional amendments we have. Sometimes they're worded in such a way that they don't necessarily mean what we think the people wanted them to mean.
Right.
And that's a real issue. I would welcome discussing that with colleagues to come up with what's a reasonable solution to those fine issues. Those would be very interesting to explore.
What's your experience with the Daubert standard? Do you have any thoughts on Daubert?
Yes. I actually think the Daubert standard may, as a general position, be a better standard because it's more complete, it's more, you can't, I believe it keeps out more junk science. But the Frye standard is what we have now, again, and that's what we're bound by, and that's what we have to follow. It was really challenging when the legislature passed the change of the evidence code, and I would have hearings on whether or not experts could testify, and the Supreme Court came down with their decision. That was not a decision, it was more of a dicta that said, we aren't certain this is something the legislature should be doing. So that was very challenging to deal with those in terms of making findings, and a lot of times the attorneys would have the same challenges that I would have, and they would make arguments under both standards, so I'd have to try and make rulings under both methods.
What would you look for in hiring law clerks?
I would look for somebody that is passionate about the law, that wants to work hard, and will work well with others. I've been very privileged to have my judicial assistant with me, not a law clerk, but a judicial assistant with me for 24 years, so it's been a long time since I've done any personal hiring for myself. But I have been involved with hiring law clerks or staff attorneys for our courts. And that's what we look for. We look for people that will have good writing skills, understand the law, understand what's expected of them as staff attorneys, that they're not decision makers. They're the ones that are supposed to advise the judge as to what the law is.
Okay, thank you.
How it's done.
You're at the end of your time. Does anybody else have any other quick questions before we move on? If you'd like to have about a minute to make any closing remarks.
Well, thank you very much for your service on this commission, taking time out in this holiday that I'm sure y'all were not eager to do, but I appreciate the work that you do. I have served as a judge for over 30 years. This demonstrates my tenacity. I've served in many administrative roles, including that of chief judge. This demonstrates my leadership abilities. I've handled all types of cases, demonstrating my knowledge of the law and how to make considered decisions. I hope that you will find my qualifications warrant my being sent as one of your nominees to the governor. I appreciate that. Thank you very much.
Thank you
Thank
so
you.
much. Happy New Year.
Happy New Year.